Welcome to Ivy and Ivy, Generations of Justice.
Hey everyone, welcome into an all-new episode of Ivy and Ivy, Generations of Justice with attorney Sam and Vic Ivy over at Ivy and Ivy Law. I am your host, Mike Leon. You know, they've got deep roots out in West Tennessee, decades of courtroom experience. Sam and Vic have been helping injured people understand their rights, especially after a serious accident. Today's episode, we're going to be talking about those accidents, specifically slip and fall ones. Sam and Vic are going to explain how they happen, when property owners are legally responsible, and what steps you need to take if you've been hurt. Sound like the commercial. If you've been hurt in an accident, call this, that, right? So Sam, let me ask you, and Happy New Year to you guys, and good to see you guys. When a simple fall happens in the state of Tennessee, when does a simple fall become a premise liability case under Tennessee law?
That's a very good question because it's very fact sensitive in Tennessee. These cases are very hard, very difficult to pursue in Tennessee. The Court of Appeals has a string of case law that's come out in the last, I would say, decade, where they go different ways on different factually appearingly similar cases that shake out differently. So it's very important to give us a call early on to examine the situation, see what the potential hazard is, and what the plaintiff did in the action that the fall was caused. So usually it's something like a defective step, maybe a curb in a parking lot, a grocery store, something, an object in the floor, something like that. Those are typical situations where a premises case may arise, and it really depends on how much notice did the company or the landlord or the owner of the property have of the condition. That's very important. Number one is notice. Was this something that just occurred 1 minute ago, or was this a situation that had been ongoing for some time? And did the employees have notice of this situation if it was like in a grocery store or something like that? Video footage becomes very important in these cases if you can get it. So that's in a nutshell, just some things, Mike.
Well, Vic, let me expand on that. I grew up in the Northeast. You would always have these businesses. Maybe they didn't shovel the snow and people would slip and fall. So in those kind of scenarios, or even expanded beyond that, what kind of duty does a property owner or business owner have to keep their place safe for visitors?
Well, it's strange you should mention that, Mike, because there was a Court of Appeals decision that just came out where the Tennessee Court of Appeals said that a property owner, in this case, it was a grocery store that had a snow-covered lot, and they had shoveled out a path leading to the entrance of the grocery store. And so the plaintiff in that case happened to walk outside that shovel path. In other words, walking on the snow-covered lot. And the Court of Appeals said that the grocery store had a duty to keep the lot maintained and to keep the not only the pathway, but the lot cleared for the individual. So now I don't know in the Northeast, but in Tennessee law, the case that just came out in the Court of Appeals is that the lot owner for the grocery store in their parking lot had a duty to keep that clear.
Mm. That's very interesting. I just happened to give the example because of where I grew up. But Sam, let me ask you, is that then the most common slip and fall injuries you guys see in Tennessee? Is it always weather related, or is it something else?
I would say something else. Just as an example, sometimes you'll have in entryways of different businesses, maybe a dark carpet or step or something that blends into the floor. We see that from time to time. Someone will trip over a hazard that is really a hazard that's hard to see, despite the client doing everything they can to look where they were going, different scenarios like that. So that's why it's very important to call us early on, because we need to know, and we will quiz our client down on how this occurred. What did they remember about the accident? Were you looking where you were going? Because they're going to get asked that question in these cases many times. What were you doing at the time before the fall occurred? So I would say that may be the most frequent type, is something dark inside the store rather than weather related. Weather related is tough because the ice melts and then the evidence disappears. So it's like a water case.
Well, speaking of the evidence, again, you're following up these follow ups here, Sam, perfectly that I can toss to Vic. But we've mentioned this before in previous episodes of how important it is to kind of document the scene. So, with that being said, Vic, how important, stress to folks here, how important it is to kind of document the scene, get photos, eyewitness accounts, incident reports before you leave.
Oh, it's very important. Of course, as Sam said, video evidence is very important in these cases. But as far as the individual that has been injured is concerned, for them to document if they had medical treatment, to be for sure and inform us, which doctors that they've been to see, and what their injuries actually are in that. Now, Mike, some of these we're talking about slip and fall, but it really winds up being a premises liability type situation. And in those, not only is there like slip and fall, but sometimes there are falling objects that occur, like from a store shelf, something like that may occur. Maybe a chandelier that's been, constructed in the wrong way and it falls, or maybe somebody's renting a property like, a bed and breakfast or something like that, and they don't maintain the balcony, and an individual was to fall off that balcony, or even a products case a slip and fall or a premises liability case, such as maybe a faulty hot tub where they haven't cleaned the hot tub and you have a mold buildup in the hot tub or maybe a bacterial buildup. So documenting the evidence of where they stayed, when they were there, the time of day or night that they were there, documenting all that, what they did following that particular mishap that occurred, and each day by day, keeping a diary or a log of it is very important.
Sam, let me piggyback on that and ask, what happens if the person kind of shares a little bit of the blame with respect to the accident? Does that kind of change anything in their ability to kind of recover damages?
Well, it does. And these cases usually get deeper into litigation sometimes than other cases such as car wrecks, do from time to time, because of the fact sensitive nature of what did the plaintiff do prior to this fall, and what did the company or the owner know about as far as the hazard goes. If the client shares some part of the blame, that's not fatal to the claim. It doesn't mean you can't bring a claim, but if we go to trial, if we're able to get to trial on that case, let's say the jury were to come back and say that the plaintiff is 35% at fault and the owner is the rest at fault for the hazard. Well, they can still recover compensation, but it would be reduced by the percentage of fault that the jury finds the plaintiff to be responsible, our client to be responsible for. So comparative fault comes in on those cases, just like car wreck cases too, or 18-wheeler cases, which we handle a lot of. And the other thing I wanted to say real quick on the evidence preservation, call us as soon as possible on one of these, because like in the 18-wheeler wrecks, for instance, a lot of times there's dash cams that we can get later. On a slip and fall, if there's video footage in a company or something like that, that loops over itself about every 7 to 10 days, even sometimes quicker than that. So the video may be gone if you don't call us quick enough. We need to preserve that ASAP.
Okay. See, that's good to know. That's good information. So, Vic, I asked you in a previous episode about these insurance companies and your years' experience, facing some of them. So how do the insurance companies usually respond to these claims, and what tactics would you advise people out there that they should kind of look out for, get ready, that they're going to use?
Well, they're going to call, first of all, and try to get a recorded statement from the injured party. And when you're in that situation, you may have just come from the doctor's office, or you may be at home on pain medication or something like that, and you may not feel the full extent of your injury. So a person that has been taking say a pain medication may respond that they don't feel too bad that day. And when in actuality, they may have a broken bone or something else that has occurred. So even though, at that moment they don't feel too bad, a little bit later, they're going to feel terrible. So that's the first tactic that they'll use, is try to get a recorded statement from the injured party. And from then, it's like a lot of our cases, it's a delay tactic that they will use to try to wait the plaintiff out, because usually these people are injured to the point where they can't work. And so they're lacking in income and that sort of thing. and it's a waiting game as far as the insurance company is concerned. They'll try to wait you out.
And Sam, let me piggyback on that one and ask you, kind of in your experience doing this, what kind of injuries are the most common that you've seen in these cases, and how they impact someone's long-term health, maybe their ability to go back to work?
Yes, sir. I mean, we have seen some significant injuries in these. We handle a lot of auto accidents and trucking cases, as you know, and those all 9 times out of 10 result in catastrophic injuries, but the premises cases can as well. And for instance, we've seen a lot of broken legs from this. Femur, I can remember a shattered femur we saw right around the knee, just a terrible injury from falling over a hazard. Head injuries, we've seen significant head injuries from premises cases, back injuries, and just terrible things that have affected our clients in negative ways. And so very important you get us involved early on to document the case, collect evidence, and investigate the potential case against the company or owner. And we can also handle, as Dad said, the insurance companies while you get better, because they may be trying to call you to get a recorded statement, things like that. Once you get us involved, they need to contact us, and they'll cease contacting you, and we can handle it from there. So that makes life easier for the injured folks, we find, as well. As they go through this process.
Vic, Sam mentioned obviously contacting you guys right away, but take us inside what the first consultation with your firm usually will look and sound like.
Well, obviously there's no fee when we speak to someone about their case. Our consultation is free, so they need to come in and talk to us at no charge. So at that initial consultation, we're going to go through obviously the facts of the case, and see where we can obtain video evidence, where we can get the medical information, which doctors or hospitals that they've attended. We'll get that sort of information, whether there are witnesses. And that gets to be very important as well, if there were any witnesses that were there when whatever this is occurred. And we've run into that not only with these slip and fall cases or premises cases, but also with dog bite cases that we've handled lately, whether there are any witnesses available that can verify what's going on. Because once we get to court, the evidence that's going to be presented is going to be the medical proof as far as the damages, but as far as the liability is concerned, it's going to be the video evidence in that and how the accident or the slip and fall actually occurred. And then the witnesses are direct testimony.
Sam, as we wrap here on this episode, and I asked you an iteration of this in a previous episode, but what would be your message to someone listening to this right now? They've been hurt in a slip and fall type accident, but they're a little unsure if this isn't even a case, right? If they even have a valid case. What would be your message to them?
My message to anyone that has been injured in a premises case and or a car wreck, 18-wheeler wreck, any type of incident, please do not hesitate to give us a call. Even if you may think the case may be iffy or you're wondering if you have a case, the phone call, the consultation is free. We're here to help and examine whether or not you have a case. We will shoot straight with you, and we will be glad to talk to you about your situation. And wish it was under better terms, but once the incidents happen, all we can do is try to pick up the pieces and put our clients' lives back together when they've been hurt in a car wreck or a premises case.
Yeah, very well said. Sam, Vic, can't appreciate it enough, guys, for all the time, the insights, and breaking this all down. Truly appreciate it, guys.
Thank you, sir.
Thank you, Mike.
Happy New Year.
And thank you to everyone out there for listening to this installment of Ivy and Ivy, Generations of Justice. I'm going to sound like the commercial right now. If you or someone you know or love has been injured in a fall on someone else's property, Sam and Vic can help you understand your options to protect your rights, like you just heard them break it all down. Do me a favor, visit ivyandivy.com to learn more. Before you go, do me a favor, hit like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks, everyone.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.